Let's now talk about estate planning do-it-yourself blunders. In this day and age, with the vast resources that we have online through the internet, there are a lot of options out there to create a do-it-yourself estate plan without using attorneys. Now, one of the attractive things for clients is that they could pay hundreds of dollars and not thousands of dollars. So from a cost savings point of view, it may make sense. But what I want to do today is I want to highlight certain blunders that are made and certain mistakes that are made when people do it themselves and not involve a competent estate planning attorney. And I want to highlight those, and I also want you to consider whether any of these limitations, if you will, on a do-it-yourself plan are worth the cost savings to you and your family. The blunder of not including a child protection trust or legacy trust in your estate plan. Those simplistic do-it-yourself estate plans usually call for your child or children to inherit your hard-earned assets with an outright distribution upon your death if you don't have a surviving spouse. In that case, all should be fine unless that child was married at the time and then ultimately goes through a divorce. Once they divorce, that ex-spouse of theirs could actually end up coming away with some or all of your hard-earned assets that your child inherited from you. Do you want that to happen, or do you want the grandchildren to get it and have it passed on through generations, or at least some other blood relative of yours, rather than the ex-spouse through a divorce or even a premature death through inheritance? If these are legitimate concerns to you, then you should speak with a qualified estate planning attorney to get a more sophisticated plan that includes a legacy trust or a child protection trust. The guardianship blunder. In your do-it-yourself will, you probably already know that you can put a guardianship provision in there so that if any of your children are minors at the time of your death and another parent is not alive, that you can appoint any responsible adult that you wish to become the guardian of your children. The question I want to ask you is this: suppose you live in a particular state or city and that guardian that you named has moved to another part of the country, and maybe that person divorced, or maybe they fell on hard times and they were unemployed now. Would you have still named that person as the guardian, or would you have considered an alternate situation because your child has now made friends in their current neighborhood and you want them to stay in the same environment? Meanwhile, that guardian has moved or their circumstances have changed, making them not a reasonable guardian. With an estate plan created by an attorney that is a professional and has experience at this, you can account for these various different contingencies. In addition, what if you haven't died and you're in the hospital and you can't come home for a number of months or weeks or days? Who will be the temporary guardian? The will not control that situation. Do you have temporary guardianship provisions in place? These are important questions for those who have children. The blunder of failing to properly fund your living trust. A living trust is only as good as the assets that it actually owns after the trust is created. The problem with do-it-yourself programs is that the service that you enroll in to do it yourself doesn't hold your hand through the trust funding process. I've seen so many situations where clients come to me with do-it-yourself trusts, and I ask, what does the trust own? And they say, well, whatever it says on this sheet here at the end called a Schedule A. And when we look at the Schedule A, we find that the deed to the property was not transferred. We find that they didn't contact their bank to make the owner of that bank account the trust, so on and so forth. And that people don't realize that they actually need to take a lot of time and energy to fund the trust properly. There's more on this subject in terms of specific asset types, but in general, my question to you is, did you properly fund your revocable living trust? If not, what assets should it be funded with, and what should it not? That is a very important question that should be reserved for a qualified, licensed estate planning attorney. The blunder of not dealing with retirement accounts effectively and appropriately using revocable living trusts. If you have a do-it-yourself trust, it's probably very, very simplistic. And then you have to decide whether you're going to make the trust the owner of the retirement account, or at least the beneficiary of the retirement account, because it can't own a retirement account. But whether you do so or not depends upon how sophisticated your trust is. For example, with most do-it-yourself trusts, there aren't the right provisions in the trust where the beneficiary that receives it through the trust can spread out required minimum distributions over multiple years, thereby reducing tax liability and stretching out that asset for a longer period of time rather than giving too much in taxes to the government. If you didn't cover this with a licensed professional estate planning attorney, then you may have made a big mistake. Although it saved you hundreds of dollars, maybe even $1,000 or more to do it yourself, it may ultimately cost your family a lot more than that in the end. Failure to account for remarriage of a spouse is one of the most common estate planning blunders that people make, especially when doing it themselves without an attorney. Whether you have a will or a trust, usually, if you're married, most people want their spouse to inherit their assets upon their death. And that sounds like a great thing, and it's probably saying that in your will or your trust. However, have you thought about this? Let's say that 5 years after your death, your spouse still has your assets that they inherited from you. They remarry, and then thereafter, that surviving spouse passes on. And obviously, through laws, their new spouse would inherit their assets. Would you want your hard-earned assets to go to the new spouse of your surviving spouse if they remarry, instead of going to some other family members like your children, your grandchildren, or someone else? That is a very common mistake that people make with simplistic estate planning done by themselves. The blunder of not properly structuring your business ownership interest in your estate plan because you didn't consult with a qualified attorney to help you with that plan. A lot of people create these do-it-yourself trusts, and the system asks you what you would like to fund into the trust, and you say, well, my ownership interest in a limited liability company or a corporation. That's fine, but just because it says it in there doesn't mean that it actually will be carried out, because a business entity, especially in New York, is a separate being in its own. And if there is no provisions in the business governing documents, such as a operating agreement or a shareholder agreement and whatnot, then what it says in your trust does not necessarily mean it's going to be carried out effectively, and that business might have to be dissolved quickly after your death, which may not have been your intention. Another reason why you should talk to a qualified licensed attorney to create a more sophisticated estate plan if you have any business ownership interest.